Welcome back to Winning Isn't Easy. I think this should be the Bite Me episode because the next topic is going to be what you say the disability carrier can come back and bite you. The 11th Circuit rejects a functional capacity evaluation because of the policyholder's reported activity. Now, we've talked about how, as part of the claims process, your disability carrier is going to have a representative speak with you. And what you say can come back and bite you. That's exactly what happened in the case of Sisong versus Unum. This is an 11th Circuit case. And the 11th Circuit covers the state of Florida, Georgia, and Alabama. So it's in my backyard. Miss Sisong was a pharmacist, and she had an on-the-job back injury that left her in tremendous pain. She applied for her Unum disability benefits and was paid own occupation benefits for 24 months. Now, in this time frame, she was treated with medication, physical therapy, medial branch blocks, steroid injections, and she didn't have any significant or long-lasting relief. She underwent a radiofrequency ablation procedure, and that did provide her with significant pain relief and improvement in her physical exam findings. Her doctor released her to go back to work, even though she told the doctor that the radiofrequency ablation had stopped working. Now, Sisong started to take gabapentin, and in the fall of 2017, as a result of seeing a new neurologist, that was prescribed because she was having back and leg pain. And this neurologist, Dr. Lifton, said that she couldn't work. Now, what did Unum do in response to all of this? Well, as the initial 24-month period of time, her own occupation benefits neared its end, Unum gathered information to determine and establish that Sisong could engage in any gainful occupation based on her education and experience. That's called the Any Occupation Standard. Now, basically, if they can establish you can do at least sedentary work, for the most part, there's going to be a compelling argument that you are no longer disabled and unable to work in any occupation. So what happened? What did Unum do? Well, as part of the Any Occupation review, Unum's representative spoke with her about her daily activities. And what did she tell them? She said that she was able to ride a stationary bicycle, exercise with her exercise ball, do yoga, walk up to a quarter of a mile, cook and clean, shop on her phone, engage in crafts like basket making while sitting on a couch. Now, all of that is going to come back to haunt her. First off, she never should have talked with the Unum folks without representation. And secondly, there is a way to tell the truth, which obviously we always want to do, but in a way that explains what the import or impact of doing those activities, how long she did them, the price that she paid for doing them, good days, bad days, how the medical condition impacted her ability to sit and stand, and how she needed to alternate sitting and standing. So there's all sorts of ways to address the level of physical activity, but to do it in a way that accurately demonstrates an inability even to do sedentary work. So Unum said, well, based on all that, you can do sedentary work. And there are 3 pharmacy jobs in your labor market that you can perform. And as a result, we're not going to pay any occupation benefits at the end of 24 months. Well, Sisong didn't give up, and she appealed. And as part of her appeal, she did what she should have done. I always want my clients to have a functional capacity evaluation. That's the gold standard to determine the objective basis of your physical restrictions and limitations. But there is always a bit of a subjective component in the FCE testing. The FCE results came back saying she couldn't do sedentary work because she couldn't safely lift more than a negligible amount of weight from floor to waist. She couldn't lift more than 5 pounds from waist to overhead. She couldn't safely carry more than 5 pounds. She would need breaks to lie down during her day, and she was unable to work a full 8-hour shift. Now, Unum said, we're not going to buy that. And she appealed to the district court. That federal district court upheld the denial. She didn't give up, and she ends up in the 11th Circuit in Atlanta. So what did the 11th Circuit Court of Appeals do? Well, let's first talk about the standard of review and how the 11th Circuit deals with whether or not Sisong could do sedentary work. Each federal circuit has its own different way of reviewing an ERISA claim and the denial or a termination, and that's called the standard of review. Remember, you've got the burden of proof. And in applying the standard of review, the 11th Circuit first reviews an administrator or carrier's decision using what's called a de novo standard of review. So the court can look at this whole file, which is the trial of your case, and the court can say, look, I'm not going to give any deference to anybody. What is it that I think? And if the court agrees with a decision to deny or terminate benefits, bingo, you're done. The court has to affirm the denial. Now, if the court doesn't agree and the policy or plan vests the administrator or the carrier with discretion to make the decision or interpret the plan's terms, the court has to review the decision using what's called the arbitrary and capricious standard of review. They don't teach this in law school. This is a differential standard of review. It gives deference to the discretion of the plan administrator or the carrier. So the court has to next really determine whether there are quote unquote reasonable grounds for the decision, and if so, uphold the denial. If the decision is unreasonable, then the court has to potentially reverse the decision if that decision has been influenced by the carrier or plan administrator's bias and conflict. In other words, they're the decider and they're the payer. There's certainly got to be a conflict, and that's a factor in whether or not the decision gets overturned. Now, in determining that Siskong was capable of sedentary work, Unum relied in part on what's called the Dictionary of Occupational Titles. It's an old Department of Labor manual, still unfortunately in use. It hasn't been updated in a million years. But the definition of sedentary work requires the ability to push, pull, lift, and carry 10 pounds occasionally. Well, the FCE showed that she could push or pull, that although she could push or pull more than 40 pounds, she couldn't safely lift more than 10 pounds. Now, what's important here is that none of her daily activities showed that she did any of that. And the court agreed that the functional capacity evaluation was perhaps accurate, but said, look, under the arbitrary and capricious standard of review, their rejection of the FCE was not arbitrary and capricious. What? That's kind of confusing, isn't it? Well, you're absolutely right. It is confusing. But what the court said was that several members of the Unum's in-house medical staff had reviewed the records and concluded that the FCE limitations were inconsistent with the reported mechanism of injury and the relative innocuous findings in an MRI 4 years earlier, that she had been released to full duty in 2017, and that her description of her daily activities appeared to exceed the requirements for sedentary work. So the court reviewed this decision on a de novo basis as step one. And the court said, look, there's substantial, reliable evidence to support Unum's determination that she could perform sedentary work. And because that decision survived the review, the court upheld the denial. Now, with all due respect to the court, I think the court was wrong. The MRI in 2016 and the decision to release her to full duty in 2017 were, in my view, irrelevant to her functional capacity at the time Unum evaluated her ability to do other work. Because at that point in time, she was being paid own occupation benefits. Now, in my mind, the real question was whether Sasong's reported activity level really was of at least a sedentary level. I think that the court clearly thought it was, but I still think that's problematic. Now, it's unclear from the decision whether she had a second level appeal and whether there was any new reasons offered up by Unum to justify the claims denial. In either case, she should have had the functional capacity evaluator and physician address whether her reported activities were the equivalent of an ability to engage in sedentary work. But I think the other lesson to be learned here is that if you're going to get a functional capacity evaluation, you should also be giving the FCE vendor or provider a copy of the activity of daily living statements and any summary of statements that you, the policyholder or plan beneficiary, have given to the disability carrier. The FCE provider should be explicitly asked as part of the FCE to address whether or not these reported activities of daily living, be they reported to the doctor, be they reported in the activity of daily living forms or in conversations with the carrier, were the equivalent of sedentary work. Then I think that the issue of the level of activity and whether it was the equivalent of sedentary work should be clear. Now, I don't agree with the court's decision, but nonetheless, this decision shows how the court applies the arbitrary and capricious standard of review and can defer to what I believe was a wrong decision in terminating her benefits. So you've got the burden of proof. The FCE will help, but you got to anticipate that they're going to argue that there are subjective issues associated with the FCE and that the activities of daily living, as reported, are just inconsistent with the results of the FCE. Got it? All right. Don't talk too much, and preferably don't talk with a disability insurance carrier, adjuster, or investigator unless you're represented by an experienced ERISA disability attorney. Thanks. Hope you enjoyed this week's episode, and I look forward to talking with you next week. If you liked this episode, please hit like, and would you also please share it with your friends and family? Better yet, how about you subscribe to our podcast? Thanks. Talk to you next week.